case briefs, and so much more. LSDat's got what you're looking for.
In a landmark 1977 case, the Minnesota Supreme Court tackled a complex scenario involving a revocable life insurance policy, a marital fallout, and a disputed trust. At the heart of the case was John W. Aughenbaugh, whose life insurance policy had gotten tangled up in a web of family affairs and led to a legal standoff. Connecticut General Life Insurance Company v. First National Bank of Minneapolis. John had created a revocable insurance trust with the bank as trustee, set to be funded by his policy for the benefit of his then-wife, Elizabeth Ann Aughenbaugh, and their 3 children. Life, however, took a twist, and John divorced Elizabeth and married Marilyn L. Melaas. This sparked the pivotal question: could John's will revoke the trust he had set up? The trust was set with the express provision that John could amend or revoke it during his lifetime, but only with written notice to the trustee. The matter was further complicated by a clause in the agreement that allowed the trustee to be changed, repealed, or altered, but only after a written notice was executed by the donor and delivered to the trustee. This served to safeguard the interests of the trustee and eliminate ambiguity. While the trial court did not consider a revocable life insurance trust as testamentary, the trust did preserve the power to revoke it through an inter vivos transaction, thereby indicating that a trust couldn't be revoked by a will if the power to revoke it is reserved through a transaction inter vivos. Agreements with such clauses provide utmost protection for the trustee, mandating any significant changes should be through a written notice. The court agreed with this interpretation, that the trustee should be aware of any considerable alterations in its obligations, including changes to or removal of the trust. While the clause permitted unilateral changes without substantially increasing the trustee's responsibilities, any significant augmentations would require the trustee's agreement. Ultimately, the Minnesota Supreme Court upheld the trial court's verdict. The disputed insurance proceeds were to go to the First National Bank of Minneapolis as trustee, verifying the district court's decision. Justice Todd, however, abstained from participating in the judgment.
Case briefs, and so much more. LSDat's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.